Within the realm of modern computer law, there are laws that invoke regulation upon privacy protection and commercial transactions. There are four main categories that can be used to classify them. They are governmental regulations, privacy regulations, laws that define computer use, and laws that regulate classified or sensitive information. Now, the first laws that were applicable towards regulating computer use were actually placed into effect some years before widespread commercial computer use. The laws included prohibiting false entries in bank records and falsifying credit institution records, prohibiting malicious mischief to government property, and prohibiting wire fraud using interstate communications systems. Despite their age, the laws assisted in crafting more specific laws for computers in the 1980s. Laws in the 80s started to respond to the more sophisticated forms of computer abuse. The laws invoked the framework of the older laws to apply to computers. Such laws passed include prohibiting tampering of public records, prohibiting fraudulent use of credit cards, passwords, and telephone access codes, otherwise known as phreaking, prohibiting unauthorized access to electronically stored information, prohibiting illegal export of software or data controlled by the Department of Defense or the Department of Commerce. Now, the concept of privacy is slightly more sensitive to deal with, as a breach of common legal principles. Most personal information is valued as a commodity on the internet, as numerous industries can utilize the data to tailor business practices. A great deal of the information are basic tidbits of data that the user already knows about themselves, but there is also information stored about users that is the result of data massaging, where an organization can draw a conclusion on users based on other bits of information. Most data is harmless in its current state, but if it is misappropriated, it can lead to disastrous consequences. The main issues occur around malicious parties accessing the data and using it for identity theft or numerous other forms of cyber foul play. The Freedom of Information Act was enacted in 1966 and was the first time in the electronic age where privacy issues were examined. Prior to this law, individuals had to demonstrate a need to gain access to the information stored about them. The law changed to reflect that the individual have a right to know such information. It guarantees access to documents within the executive branch of the government. It does not, however, apply to records held by elected officials or private organizations. Certain agencies have the right to withhold information only if the records may interfere with active law enforcement, involves confidential informants, or pertain to foreign intelligence. The Privacy Act defined the rights of individuals with regards to the computerized information stored about them. The government and certain private entities are now required to safeguard the private information they collect and store. The law also set up standards for how the government collects, maintains, uses, and disseminates personal information. Personal information under this law is ensured to be collected only for necessary and lawful purposes. Personal records are legally only to be used for their intended purpose under this law. The Electronic Communications Privacy Act of 1986 offers a single, clear statement of individual rights with respect to electronic information. It enacts a regulation prohibiting interception of communication transmissions regardless of their media of transmission. The act had passed due to law enforcement agencies overutilizing wiretapping of suspected crime figures, making such acts illegal without proper authorization. The Computer Matching and Privacy Protection Act allows individuals to receive recovered monetary damages from the government if the government is proved to have violated willfully their privacy under the Privacy Act. The Act requires federal agencies to follow specified and standardized procedures for information exchange. The law also regulates matching databases from different governmental agencies. While the law provides some protections for the individual, it also allows information collected for one purpose in a government agency to be used by other agencies as long as proper procedures are followed. I'm Ross Miron, and thank you for listening.